Good afternoon, friends. A major breakthrough and the first breakthrough has been achieved in the matter of litigation in GST, wherein the department considers a post-sale discount as a service being rendered by the recipient of the discount and alleges that GST should be charged on a service invoice by the recipient of the discount instead of a commercial credit note being provided by the supplier or the provider of the discount. Let us understand in detail the supply chain process in every trade. There are four hands through which the good passes on in every trade before it reaches to the customer or the end consumer. From the OEM to the distributor, distributor to wholesaler, wholesaler to retailer, and from the retailer thereafter it reaches to the consumer. Now, many a times there are channel discount. For example, in the sale of electronic items, say mobile phones, the price always travels southward as one goes down in the timeline. So, if a mobile phone has been sold for 1 lakh plus 18,000 GST on day 1, maybe after 1 month the price drops to 80,000 and the OEM provides a post-sale, pass-back or channel discount, whatever you might call it, to the distributor. Distributor provides to the wholesaler, wholesaler to the retailer, and thereafter it goes on to the customer and the mobile is sold at 80,000 rupees plus GST. This post-sale discount is passed on as a commercial credit note from the OEM to distributor to wholesaler to retailer, and thereafter it flows to the customer. The allegation of the department is that this post-sale discount, which is passed on through a commercial credit note, is actually a service of business auxiliary, technical or marketing service provided by the distributor to the OEM, wholesaler to the distributor, retailer to the wholesaler, and so on. And it is the recipient of the commercial credit note who should have passed on and raised a service invoice with GST in this transaction. However, section 15 subsection 2E is very clear that in case of post-sale discount where there is no pre-sale agreement, there cannot be a GST credit note. Further, in this case, there is no service which is rendered. Just because the term incentive or subsidy is mentioned in the credit note or the agreement, it cannot be termed as a service where the transaction is a mere discount simpliciter, as was held in the case of Supreme Paradise by the Honorable Madras High Court in a landmark judgment, the first relief in such cases in February 2024 itself. In an earlier judgment by the Appellate Advanced Ruling Authority of Maharashtra in the case of MEK Peripherals, the Honorable Authority had in a similar case held that it is to be treated as a service by the recipient of the discount. However, the Honorable Madras High Court has disregarded such a contention of the department that this post-sale discount is actually a subsidy or an incentive and forms a part of the transaction value under section 15 subsection 3 clause E of the CGST Act. This judgment therefore comes as a major relief, especially to the distributors, wholesalers, retailers, some of whom are not very big traders. Therefore, they can take the benefit of this judgment. Lakhs and lakhs of traders would be impacted by this judgment, and the benefit of this judgment can be taken by them. Thank you very much for listening. Stay tuned. Please do like, share and subscribe to this channel. Thank you very much.